Joining us today, and welcome to today's CLE webinar. Firstly, Legal Aid Queensland acknowledges and respects the First Nations custodians of the land where our offices stand and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders, law, customs and creation spirits. We recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander peoples play in our community and improving our legal system. So welcome again. My name is Kiara. Apologies, I'm off-site again today. Today's webinar is Respectful Workplaces, Supporting Victims of Workplace Discrimination and Harassment. And we are kindly joined today by Jessica and Sienna, who are civil lawyers in our Human Rights, Anti-Discrimination and Employment team with the Civil Justice Services here at Legal Aid. Thank you for joining us. Oh, sorry.
Sorry, there you go. You jumped the gun there. Sorry.
Just a quick content warning for today's webinar. There will be some content related to sexual harassment and gender and sexuality-based discrimination. So if you do need to, please reach out to any of the numbers mentioned below. There's Lifeline, Beyond Blue, 1-800-RESPECT, 13 Yarn and Q Life. Those numbers will also be a part of the presentation slides that we send out after, so you can share them with your clients or amongst your organisation. A little bit of housekeeping before I hand it over to our presenters. The webinar is being recorded. The laws and content discussed today is accurate as of today and may be subject to change. Any information is on our Community Legal Education Resources page on the Legal Aid Queensland website. And if you do have any technical difficulties, you will need to reach out to the GoToWebinar customer support team for assistance. The presentation is roughly about 40 minutes. It may be a bit longer. I know there have some fabulous case studies to go through, which would be really great for the content. We will have questions at the end. If we are running over time, you are welcome to send the questions through to the webinar's email, and I'll make sure they get forwarded to the team to respond to when they're able. Please type any questions into the question box, and you can access a PDF copy of the presentation slides in the handout box, but I'll also email out another copy of those slides once there is a link to the recorded version. And with that, I'll hand it over.
Thank you, Kiara, for your acknowledgement of country. We'd also like to pay our own respects to the First Nations custodians of this land, and in doing so, we usually have an established practice in our team of sharing some knowledge we've learned about local First Nations leaders or organisations. So today we'd like to acknowledge the important work of a Meanjin-based Indigenous-led organisation called Two Spirits, Aboriginal and Torres Strait Islander Corporation, which is dedicated to supporting the health, well-being and cultural strength of Aboriginal and Torres Strait Islander LGBTIQ+ sister girl, brother boy and rainbow mob peoples across Queensland. So we acknowledge the impactful work of Two Spirits in offering access to culturally appropriate and accessible services through environments that are free from discrimination and stigma.
We're presenting today as part of Pride Month, which is a celebration of the LGBTQIA+ community and a time to reflect and honour the community's history, celebrate diversity and reflect on how to improve our advocacy for equal rights and protection from harassment. Now, there are some legal terms we're going to be using today, including discrimination, sexual harassment, victimisation and vilification. For those who are not familiar with the legal definitions of these things, we'll just cover that quickly now because we know not everyone online is necessarily a lawyer. So discrimination we'll use in terms of treating a person or group less favourably than others due to protected personal traits. These include things like gender, sexuality, sex, race and religion. This discrimination can be direct or indirect. So direct would be explicitly refusing to hire someone, for example, due to their gender, or indirect, and those things look neutral on their face, but they are discriminatory because they unfairly impact on someone. Sexual harassment, any unwelcome conduct of a sexual nature that is done to offend, humiliate or intimidate another person, or where a third person watching on would think that that person would be offended, intimidated or humiliated. This includes things like uninvited physical intimacy, such as touching in a sexual way, uninvited sexual propositions, and remarks with sexual connotations. Victimization, subjecting or threatening to subject someone to a detriment because they made a complaint about discrimination or sexual harassment, or they intend to make a complaint or assist someone else to do so. So it's like a punishment for speaking out. Vilification, a public act that incites hatred, severe ridicule, or serious contempt towards a person or group based on protected attributes, such as race, religion, or sexual identity. It's often referred to as hate speech or hate-based conduct more colloquially. And finally, harassment, unwelcome conduct of a demeaning nature in relation to the person harassed, again, in circumstances where that third person watching, and in those circumstances would have anticipated that the person subject to the harassment would be offended, humiliated, or intimidated.
So what we know from the statistics is that our LGBTIQ+ community are one of the most affected cohorts when it comes to workplace sexual harassment and intersectional discrimination. The 2025 to 2026 Inclusion at Work Index has revealed that 46% of QIA+ workers reported discrimination and or harassment in the last year, compared with 26% of non-LGBTIQA+ workers. This means that LGBTIQ+ workers were more than 1.5 times more likely to experience these behaviours. And on top of discrimination and harassment, this community is also more at risk of experiencing vilification on the basis of their sex, gender identity, and or sexuality. Intersectional discrimination is a concept describing how different aspects of a person's identity, such as race, gender, class, ability, and sexuality, overlap to create a unique compounding forms of discrimination and marginalization. It highlights that disadvantages cannot be understood in isolation. So for this reason, discrimination cases brought by members of the LGBTIQA+ community often have more than one cause of action. And the effect of all of this really is to highlight why conversations about workplace sexual harassment and discrimination during Pride Month are so important. So not only to raise awareness of the unique challenges faced by this community year-round, but also to explore the practical barriers that can arise when reporting this conduct, enforcing legal rights, and seeking effective remedies. So we're hoping that in today's webinar, we can discuss the ways in which we as all practitioners in various fields and across different roles can identify these issues and assist our clients navigate them.
So the topics we will cover today are going to focus on our sexual harassment laws in Australia, and more specifically in relation to the history of the Respect at Work reforms, what people can do if they experience sexual harassment, and how the Respect at Work reforms protect victim survivors, trends in sexual harassment cases, and how Legal Aid Queensland can help and how to refer clients to us if that's something you want to do. There will be, as flagged already, case studies woven throughout the presentation because they concern contraventions of Respect at Work laws. They do involve some pretty appalling and offensive behaviour. We will flag it before we jump into a case study so that anyone who wants to jump offline or mute that part of the presentation has a moment to do so, and we'll change the slide as soon as we're finished speaking about the case study so that you can unmute and rejoin us when that section is over. So first, I'm going to whip through a brief history of Respect at Work. You'll see the slide a couple of times, mostly because I'm really proud of my timeline putting together skills. But we'll look at how the reforms came about, what they changed, and how these have translated in practice. So women's groups began to press for sex discrimination and sexual harassment laws way back in the 1970s, building on Australia's ratification of the International Labour Organisation's Discrimination, Employment and Occupation Convention in 1973, and the UN Convention on Elimination of All Forms of Discrimination Against Women in 1983. The following year, in 1984, we got the Sex Discrimination Act, fondly referred to as the SDA, prohibiting sexual harassment at work. Since then, the rate of change has been pretty slow. You can see there's a bit of a gap there on the timeline. The statistics from the Australian Human Rights Commission's National Inquiry into Sexual Harassment in Australian Workplaces in 2020 show that sexual harassment is a pervasive systemic issue across all Australian industries. That report also identified flaws in the existing laws that allow sexual harassment and discrimination to continue. It also found that most sexual harassers are older men, and that LGBTQIA+ and Aboriginal or Torres Strait Islander workers are more likely to experience sexual harassment than others. That report ultimately made 55 recommendations that a suite of law reforms occur. The Australian government did take these recommendations on board and has been implementing them since 2021 through the Respect at Work Amendment Act and other legislation altogether known as the Respect at Work reforms.
So this legislation amended, among other things, the Sex Discrimination Act and the Fair Work Act to bring in new protections and mechanisms to address unlawful sexual harassment, sex discrimination, and victimisation in the workplace. These reforms essentially shifted the system from a reactive complaints-based model to one more focused on active prevention. So the Respect at Work reforms changed the Fair Work Act by prohibiting sexual harassment in connection with work, expanding the anti-bullying jurisdiction of the Fair Work Commission to allow it to make orders to stop sexual harassment at work, and clarifying that sexual harassment in connection with an employee's employment can be a valid reason for dismissal. It also updated the Sex Discrimination Act and the Australian Human Rights Commission Act to prohibit conduct that results in a hostile workplace environment on the basis of sex for all employees and potential employees, introduced a positive duty on employers and businesses, requiring them to take proactive, reasonable measures to eliminate workplace sexual harassment, sex-based harassment, and discrimination, give new functions and powers on the Commission to monitor and assess compliance with the positive duty, a new inquiry power on the Commission to allow it to inquire into and report on issues of systemic unlawful discrimination or suspected systemic unlawful discrimination across all 4 federal discrimination acts, and implemented equal cost provisions to protect complainants of sex discrimination and sexual harassment from being ordered to pay legal costs if they run their matter through the courts and lose.
So back to my favourite slide. If we're looking towards the right now, towards those green bits on the timeline. So in 2024, the previous Queensland government passed the Strengthening Protections for Queensland Workers Amendment Bill, which made significant reforms to Queensland's Anti-Discrimination Act, including by broadening the basis on which discrimination is prohibited to include potential pregnancy, sexual orientation, and subjection to domestic or family violence. And it introduced the positive duty to prevent discrimination, sexual harassment, and harassment on the basis of sex to Queensland. Sadly, last year, the LNP government halted these reforms indefinitely, and on 13 May this year, discharged the bill, meaning it is no longer before the Queensland Parliament. However, just last week or the week before, the government gave a media release advising that a statutory review of the Queensland Human Rights Commission, our Human Rights Act, and the proposed but uncommenced amendments to the AD Act is going to occur, led by the now retired Justice Flanagan. That review is intended to conclude in March 2027. It's not quite clear to me what the basis for the review is, given that the Human Rights Act isn't statutorily due to be reviewed until 2027, and the amendments to the AD Act, as previously introduced, were the subject of extensive consultation. But we soldier on.
So for those attending today who might not be familiar with our laws relating to sexual harassment and sex discrimination, I'm just going to cover off on that quickly about what our legal landscape looks like to give you a bit of context on what people experiencing this at work can do. So as you can see on this diagram here, we have several laws that protect people from sex-based harassment, sexual harassment, victimization, vilification, and sex discrimination at both the state and federal level. So when looking at what clients can do if they are experiencing these things, this is a summary essentially of the legal avenues that they can take. For many clients, they could make a complaint or application in any of these jurisdictions at either the state or federal level, but they need to choose one. And in our clinic, when we are advising clients, we're mostly providing clients with advice about which jurisdiction may be best for them based on the facts of their case, where and when the conduct happened, what outcomes they want, and other relevant factors which might influence the advice that we provide. We won't be covering that type of content today, choice of jurisdiction content, which is basically, what influences which legal avenue for a client to choose, for example. But what I will do is outline what the jurisdictions cover and how these Respect at Work reforms have been operating in practice to protect victims. So I'm going to start off at the state level with the state anti-discrimination legislation, that is the Anti-Discrimination Act 1991. And essentially this act makes discrimination on the basis of sex, gender identity, sexuality, sex characteristics, pregnancy, family responsibilities all unlawful in the areas of public life such as work, education, accommodation, provision of goods and services, and etc. It makes sexual harassment unlawful wherever it happens in Queensland, and vilification on the grounds of race, religion, sexuality, sex characteristics, or gender identity unlawful. Two of the most significant differences in the state legislation as compared to the federal laws is firstly that sexual harassment is unlawful wherever it happens, so it does not need to be confined to work-related contexts, and so it's able to capture more conduct. This is especially relevant for clients who may have experienced sexual harassment via text messages, outside of work hours, at a bar or restaurant, while attending certain venues, while at university, or any other space which has no connection to work. And secondly, there are protections against vilifications on the grounds of religion, sexuality, sex characteristics, or gender identity under our state laws, whereas at the federal level, it only makes vilification unlawful on the ground of race. Now, common examples of what vilification can look like in the workplace and experiences that we hear from clients can include things like hate speech, so using slurs or derogatory language targeting an employee's sex or gender identity and or sexual orientation in front of other staff, discriminatory banter or jokes, so passing around offensive emails or publicly ridiculing a co-worker's sex or gender identity or their orientation or physical disability to get some kind of laughter or contempt from others. And it can also be things like online or public harassment, so posting inflammatory, hateful, or mocking content about an employee or a group of employees on public social media platforms or company forums, for example. The issue with our state laws regarding vilification, which we've seen from case law as it's been developing, is that the element of inciting hatred is very difficult to prove, and we have quite a few contradicting decisions that exist on this point. So this means that for many clients, there is a relatively high degree of uncertainty and risk involved in pursuing vilification claims. And under our state anti-discrimination laws, employers and principals can also be vicariously liable for acts of their employees or agents if they engage in any unlawful conduct under the Act, unless they can show that they took reasonable steps to prevent this conduct from happening. And we might just go to the next slide, thank you. So the body that deals with complaints under the Anti-Discrimination Act is the Queensland Human Rights Commission. And the process for making a complaint essentially follows this structure. So you lodge a complaint in writing. It will then be scheduled, if it's accepted, for a conciliation conference. If it's not resolved at that conciliation conference, a client can choose to either end the matter there or proceed to a tribunal. And at the moment, it's the two tribunals. So for non-work-related cases, it's the Queensland Civil and Administrative Tribunal, or work-related goes to the Queensland Industrial Relations Commission.
Alrighty, so we are going to jump into one of those case studies. So if you would like to mute us or pop offline, now is your cue. Now, this is the case of Brosnahan and Ronoff, and this is one case where the complainant successfully established both sexual harassment and vilification. This is quite an old case now, decided in 2011 by QCAT. Ms. Brosnahan is a transgender woman. On the 9th of April in 2009, after midnight, while she was asleep at home, she was woken up by yelling from the footpath outside her house. 4 people, including a neighbour, were shouting and screaming abuse, including statements such as, I should have put these on the slide, I don't want to say them. Warning, you fucking faggot, you have your fucking dick in a jar. The neighbour then wrenched and snapped one of the fence palings and shouted, has anyone got a box of matches so we can burn the fucking faggot's place down? Now, those are direct quotes. Ms. Brosnahan was understandably terrified by this conduct and experienced anxiety and stress. Afterwards, she continued to feel unsafe at home after the incident. During the proceeding, Ms. Brosnahan was represented by the then Australian Transgender Support Association of Queensland, that's now QTrans, and the tribunal held that this incident constituted 3 separate contraventions of Queensland's Anti-Discrimination Act. So first, sexual harassment, because Mr. Ronoff's statement about Ms. Brosnahan's genitals had a clear sexual connotation and were made with the intent of offending, humiliating and intimidating Ms. Brosnahan. Vilification on the grounds of gender identity, because the conduct occurred on a public footpath. It was observable by neighbours. The words used to indicate Mr. Ronoff's serious contempt for and severe ridicule of Ms. Brosnahan because she is a member of the trans community, and incited that behaviour in others by inviting his associates to join him in burning the house down. And finally, serious vilification. Now, this is no longer, this offence no longer exists. It's been sort of put in the criminal law. But as it then was, serious vilification because of the threat in what the tribunal termed a gang-style attack. The tribunal ordered Mr. Ronoff to pay Ms. Brosnahan $10,000 for vilification and $5,000 for sexual harassment. Now that's pretty low, but we'll come to the increases in compensation later. One other matter I'd like to mention from this case is in relation to discriminatory conduct that is reported to police. So it's not uncommon for conduct that may also be vilification or sexual harassment to be reported to the police. And sometimes the police then take no action. Now, that's not directly relevant to a complaint under the Anti-Discrimination Act because the police apply different legal tests. They'll apply the criminal legal tests and different standards of proof to their investigations. So civil matters have a burden of proof that is on the balance of probabilities, whereas criminal matters are beyond reasonable doubt. So that's much higher. And so it is entirely possible that there's insufficient evidence capable of supporting criminal charges, but a plethora of evidence sufficient to support the lower civil standard of proof. And that was a comment made by the member in this case as well.
And now we'll move to, if we go back to that diagram, so now we're going to look at the state employment laws from this perspective. So for workers who are not covered by the Fair Work Act, so this is state public sector, local government employees, and certain statutory authorities, there are several protections against discrimination under the Industrial Relations Act. But our presentation is not going to cover these laws or the process for making complaints in this jurisdiction. But what I wanted to do is just flag that this does exist and there are protections under this legislation. Now, at the federal level, we have, which will be our main focus today, we have the Fair Work Act and the Sex Discrimination Act. So the Fair Work Act applies to most private employers. So it protects employees from discrimination, adverse actions such as dismissal, and since the commencement of the Respect at Work reforms, also sexual harassment. And the body that deals with these applications and complaints is the Fair Work Commission. Now, the prohibition on sexual harassment was one of the most significant Respect at Work reforms, applying broadly to workers, prospective workers, and persons conducting businesses or undertakings who are harassed in connection with work. It's only the victim survivor who needs to have a connection to the workplace. The harasser does not need to be an employee of the same employer or a worker for the same business. However, where the harasser is an employee or worker, employers or principals can also be held responsible or vicariously liable for sexual harassment committed by their employees or agents. So these reforms essentially provided 2 new applications that workers can make to the Fair Work Commission. So it can be an application for an order to stop the sexual harassment in connection with work, and we're calling that option A today, or an application for the Fair Work Commission to deal with the sexual harassment dispute, which is option B. And then option C is that a worker can make both of these applications at the same time. So if we look at option A first, this is a preventative measure. The purpose of stop orders is to essentially allow workers who have been sexually harassed to remain in the workplace without the risk of the harassment continuing. Their purpose is to prevent the conduct from continuing to occur. The stop sexual harassment orders are designed as a quick response, so they're meant to be dealt with by the Fair Work Commission within 14 days to stop harmful behaviour. And the process usually involves lodging an application with the Fair Work Commission. Then the Commission will send the application to the employer and each person named in the application, including the perpetrators of sexual harassment, and then they will be required to provide a response within 7 days. Following this, the Commission will then gather information about the application and can either refer the case to a conciliation conference or straight to a hearing. The conciliation conference in this space is voluntary, but if the person making the application or their employer does not want to go to it, or they can't reach an agreement at that conciliation, the application will then be listed for a hearing. At the hearing, each party will need to prepare evidence and make submissions on the key issues, i.e. whether sexual harassment has occurred and whether there is a risk of the sexual harassment continuing in the future. Unlike bullying, sexual harassment does not need to be a repeated behaviour for a stop sexual harassment order to be made by the Commission. A once-off occurrence may be enough, depending on the nature or quality of the action or statement made, keeping in mind the requirement that the Commission still needs to be satisfied that there is an ongoing risk of the harassment continuing. If the applicant is successful, the Fair Work can make practical orders, so anything other than for compensation, to prevent the worker from being sexually harassed at their workplace. So this could include, for example, prohibiting the worker from operating in the same room or team as the perpetrator or perpetrators of sexual harassment, and requiring the employer to provide additional training to staff, for example. In the recent cases where the Fair Work Commission have considered applications for stop sexual harassment order, most of the applications have failed in the circumstances because either the employee had either resigned or the perpetrator no longer worked at the same location, and or there was no foreseeable risk that the person named would continue to sexually harass the applicant at work. These are really important considerations to bear in mind, because if clients have no intention of staying at the workplace, say if they're thinking of resigning, or the perpetrator of sexual harassment has been transferred or will no longer be at the workplace and there's genuinely no risk of it continuing, then these stop orders are not going to be very useful. Another thing to note is that the Commission cannot order compensation when making purely a stop order under this option A. So if a client wants to seek compensation for harm suffered because of past sexual harassment, they need to go with option B or option C. Clients can also do options A and B at the same time. Which is, to make that very confusing. Option C is essentially when a client is wanting to make a stop order and also be compensated for the harm. So that's what we're going to call option C. A worker can also progress to an option B application if their employer or the perpetrator does not comply with the stop order, for example. So now if we turn to option B, so this is when dealing with a complaint about the harm caused by past workplace sexual harassment, and this type of application was implemented in our laws to basically complement the anti-discrimination legislation, enabling people who experience sexual harassment in connection with work with an alternative pathway to initiate civil proceedings. Unlike a stop order, workers can complain about workplace sexual harassment to the Fair Work Commission, regardless of whether they still work at the workplace or whether there is any risk of future sexual harassment occurring. In addition, there are a wider range of outcomes available, including orders for compensation and pecuniary penalties. So pecuniary penalties are essentially fines imposed on employers or companies or individuals for breaching certain sections of the Fair Work Act. So this pathway might be a better alternative for a client who has been subject to sexual harassment and other breaches of the Fair Work Act, who wants to seek pecuniary penalties in addition to compensation. In one of the most recent cases, Clark and Beeler Constructions Proprietary Limited, the court dealt with applications for a sexual harassment dispute alongside other contraventions of the Fair Work Act, including a breach of modern award, failure to make payment, failure to provide payslips, and failure to provide a copy of the Fair Work Information Statement and an application for pecuniary penalties. So the Commission can deal with the dispute, including by conciliation, mediation, making a recommendation, or expressing an opinion. If the dispute is not resolved, the dispute may proceed to a hearing in the Commission by consent or to one of the federal courts by application.
Alrighty, so we're going to put that into a bit of practice now. We've got another case study. And again, this contains some pretty heinous conduct. So if you would like to mute us or jump off, now is the time to do so. So our understanding of how the sexual harassment dispute applications operate in practice is limited, in addition to the stop orders being fairly limited, because since the jurisdiction was introduced 3 years ago, there hadn't been a single published decision until March this year, and now we have 2 or 3, I think, and they're just flying off the works, hot off the press. So we've chosen to speak about Eklom and Marshall today, and so we'll break down some key takeaways. So Mr. Eklom filed a sexual harassment dispute under the Fair Work Act and sought compensation and those pecuniary penalty fines arising from the sexual harassment. The basis of his complaint was that a contractor and a customer of his employer began targeting him at work with homophobic and sexualized comments. These included things like, "Oh, the gay boy is cleaning again. He probably likes it that way," and things like that. Over time, the comments began to escalate, becoming things like, "You sure you are not just into blokes? You getting tied up and left in a shed? He's probably used to it. He's bending over to clean the shed like he is practicing for something. And yes, we know you like it that way," and probably spends more time on his knees than actually working. Escalating even further, the comments included that Mr. Eklom would get raped in the shed, that if someone followed him into the shed, it would turn into a sex party. Further, on one occasion, Mr. Eklom texted one of the customers, "Hey," and the reply he got was, "I'm at home, you put." They would also initiate unwanted physical contact by shoving or bumping into Mr. Eklom. Mr. Eklom made an internal complaint to his employer and took some personal leave, after which he was dismissed. He was diagnosed with anxiety, stress, and a depressive disorder with onset dated from when the contractors and customers' conduct began to escalate. Now, the decision was given by Judge Vasta on the Federal Circuit and Family Court, and His Honour observed that it was irrelevant whether Mr. Eklom actually is or has a homosexual orientation. What is relevant and what is prohibited is that he was harassed because the orientation was imputed to him or put upon him in his workplace. His Honour then proceeded to use cases brought under the Sex Discrimination Act as a basis on which to decide the amount of compensation that ought to be ordered. The court ordered the contractor and customer to jointly pay $90,000 to Mr. Eklom as compensation for what he experienced. Judge Vasta then turned his mind to the issue of pecuniary penalties and fining the contractor and customer for breaching the Fair Work Act. The object of these fines is specific deterrent of the Act contravener and general deterrence of other would-be contraveners. At the time, the maximum fine payable was $18,780 by an individual. His Honour did apply a discount to the full amount of that penalty on the basis that there was no power imbalance between Mr. Eklom, who was a manager or supervisor, and the two harassers. His Honour ordered that each of the two harassers pay $13,000, so together $26,000 in pecuniary penalties.
Thank you for that. Now we'll turn to the federal anti-discrimination legislation called the Sex Discrimination Act 1984. And essentially this act makes it unlawful to discriminate against people on the ground of sex, sexual orientation, gender identity, intersex status, marital or relationship status, pregnancy or potential pregnancy, breastfeeding or family responsibilities in the area of work, accommodation, education, provision of goods and services, and etc., to harass someone on the ground of sex, to sexually harass in connection with areas of public life, which I've popped on the slides, for a person to victimize someone who's made a complaint or alleged contraventions of the Act, for a person to subject another person to a workplace environment that is hostile on the ground of sex. And it also places a positive duty on employers or people conducting a business to take reasonable steps and proportionate measures to eliminate, as far as possible, certain discriminatory conduct. The type of discriminatory conduct which falls under this positive duty is sex discrimination, sexual harassment, hostile work environments, and victimization. And the body that deals with these complaints made under the Sex Discrimination Act is the Australian Human Rights Commission. And the process for making a complaint is very similar to the Queensland Human Rights Commission. The only difference, one of the main differences, is essentially instead of being able to, if your matter doesn't resolve at that conciliation stage, instead of going to a tribunal, you will have the option to go to a federal court, essentially.
Alrighty, so we've got our next case study now. So this is, again, a cue to jump off or mute us if you would like to do so. So Tickle and Giggle is a recent case brought under the Sex Discrimination Act that generated quite a lot of attention. We're also going to talk about the appeal of that case, which was handed down recently. Ms. Tickle is a transgender woman. In February 2021, she sought access to an app called the Giggle app, founded by a woman called Sally Grover. Giggle was an app for social communication between women and operated under a policy that excluded all people who were of male sex at birth. So that naturally includes transgender women. As part of creating her account for the Giggle app, Ms. Tickle was required to upload a selfie, which was then scanned by AI software designed to detect if a person was male, and if so, then refuse them access to the Giggle app. Ms. Tickle was granted access by the AI software to the app. In September or October 2021, Ms. Sally Grover reviewed Ms. Tickle's selfie, considered her to be male, and removed Ms. Tickle from the app. After attempting to resolve her removal with Ms. Grover directly, but informally, Ms. Tickle made a complaint to the Australian Human Rights Commission under the Sex Discrimination Act, alleging that she'd been discriminated against on the basis of her gender identity. The Human Rights Commission listed the case for a conciliation conference, but Ms. Grover and the Tickle app people declined to participate. Ms. Tickle accordingly then lodged a proceeding in the federal court. Now, at first instance, Ms. Tickle argued that she had been subject to direct discrimination or alternatively indirect discrimination by reason of her gender identity in the context of the provision of services by the Giggle app. Giggle and Ms. Grover argued that they had discriminated against Ms. Tickle on the basis of her sex, which they contended was unchangeable from birth and was thereby male, and therefore they could not have discriminated against her on the basis of her gender identity. So they essentially seem to consider that gender identity isn't a thing that exists. They also said that this discrimination was not prohibited because the Giggle app was a female-only app and therefore exempt from the prohibition on discrimination in the Sex Discrimination Act because it was a special measure to achieve equality between men and women, which is like they're terming it like positive discrimination, which is allowed in some circumstances. Justice Bromwich found that Giggle and Ms. Grover's arguments failed because there is 30 years of case law establishing that on its ordinary meaning, sex is changeable. There is a clear parliamentary intention to prohibit discrimination on the ground of gender identity, and that came via amendments to the Sex Discrimination Act in 2013. And that even if the Giggle app was a special measure to promote equality between men and women, that doesn't excuse discrimination on the basis of gender. Justice Bromwich also found that Ms. Tickle was not directly discriminated against by reason of her gender identity, because when she was excluded from the app, Giggle and Ms. Grover were not aware of her gender identity. Rather, her exclusion was a byproduct of excluding those perceived to be male using visual criteria. However, she had been indirectly discriminated against by reason of her gender identity, because Giggle and Ms. Grover had imposed a condition on access to the app that users must be cisgender women, and they must have the appearance through their selfies of cisgender women. Such a condition operated to disadvantage trans women like Ms. Tickle. Giggle and Ms. Grover's knowledge about Ms. Tickle's identity was not relevant here. It is unordered that Ms. Tickle received general damages for the indirect discrimination. Ms. Tickle also made an argument that she should receive aggravated damages, which is compensation for the way the matter is conducted. And Justice Bromwich did find that Ms. Grover's actions in laughing at an offensive caricature of Ms. Tickle while giving evidence in court was grounds for aggravated damages, but that the amount was so slight and unquantifiable that it simply formed really part of the amount ordered as general damages. Other conduct that Ms. Tickle's counsel argued was aggravating, such as online comments and consistently misgendering Ms. Tickle and Ms. Grover instructed her counsel to do that as well, were made in a bona fide belief that they could not, and therefore could not be found, could not form a foundation for damages. Of course, there was an appeal. Now, Giggle and Ms. Grover appealed the primary judge's decision, again issuing blanket denials that any discrimination had occurred on the basis of gender identity, arguing that the Giggle app was a special measure and sex could not be changeable. So all the same stuff that they argued the first time. Ms. Tickle cross-appealed, so she also appealed on the finding that there was no direct discrimination, and she sought a larger award of damages on that basis. Ms. Tickle won again on appeal and received twice the amount in compensation. The full court found that the Sex Discrimination Act defines gender identity as including gender-related identity and gender-related characteristics, including appearance. And that since 1993, courts have recognised that as a matter of common usage, a person's sex was not fixed by their sex at birth. And then since 2013, the Sex Discrimination Act has explicitly extended the protections it affords to transgender people. The full court also held that Giggle and Ms. Grover excluded Ms. Tickle from the Giggle app and refused to readmit her on the basis of her gender-related appearance by reference to her selfie. They found that this was direct discrimination by reference to a characteristic that pertains to people of Ms. Tickle's gender identity, being transgender women, and not indirect discrimination. There was no indirect discrimination because there was no facially neutral condition imposed or term imposed on the access to the app. Rather, there was a decision-making tool to facilitate the exclusion of a category of people, men, on the ground that they did not fall within Ms. Grover's conception of women. The result of applying that tool was direct discrimination. Now, Ms. Tickle was entitled to slightly more general damages on appeal and a significant amount more for aggravated damages on the basis that a bona fide belief is not a complete answer to aggravated damages and can't get you out of them completely. The conduct of a court case must be justifiable or proper. The full court found that Ms. Grover's conduct was not justifiable or proper because conducting her defence did not require her to refer to Ms. Tickle using male pronouns or portray Ms. Tickle as a predatory male. The full court described these aspects of Ms. Grover's conduct during the case as gratuitous, disrespectful, and unnecessary to the conduct of her case and hurtful to Ms. Tickle. So a big couple of cases. Since the appeal decision was handed down, we note that there have been comments made by Angus Taylor, Leader of the Opposition, that should the LNP be elected at the next federal election, he intends to amend the Sex Discrimination Act to redefine sex in a binary manner. So again, we soldier on.
So like where the Giggle app could be sued in addition to Ms. Grover, employers and principals can also be liable for unlawful conduct of their employees or agents under this act. So under the federal laws, there is a higher standard for employers to be able to defend a claim for vicarious liability. Under the federal laws, employers need to show that they took all reasonable steps as compared to the Queensland legislation, which says that a respondent took, I'm not sure where we were all up to, but essentially we were just talking about, just for a little summary of anyone who wasn't before we got cut off, but essentially just talking about how the wording of the legislation is slightly different with respect to vicarious liability under the Queensland laws versus the federal laws. And essentially this use of the word all is significant, and the courts have acknowledged that as well. So it's not going to be enough to just take some of the reasonable steps that an employer should take to prevent their employees from doing this. And it will depend on the circumstances. So the nature of the workforce, the size of the organisation, what was available, and history of unlawful discrimination or sexual harassment. And the focus is really upon preventative measures and steps taken before any relevant act actually occurs. So whether or not an employee has complied with the positive duty is an additional factor which courts can consider when assessing whether they have taken all reasonable steps. So the introduction of a positive duty was significant because it shifts the responsibility from individual employees reacting to incidents to employers actively taking steps to prevent them. So if an organisation fails to meet these obligations, anyone can report concerns about non-compliance directly to the Australian Human Rights Commission by going onto their website and completing the official positive duty form. And I've just included a little bit of information here. This is what the website looks like. And if you scroll down, it says complete the form. But once the Commission receives this form, if it reasonably suspects non-compliance, it can conduct formal inquiries into the organisation. It can offer support to help the business meet their obligations, enter into enforceable undertakings, or issue compliance notices that can be enforced by the courts. However, something important to note is that this positive duty form is specifically for reporting organisational non-compliance. It will not start an active complaint against another person or an employer. So if clients are wanting to make a direct complaint about discrimination or sexual harassment against them, filling out this form will not start a complaint for them. Hopefully all of this clears up what kind of legal avenues are available to clients and how the Respect at Work reforms have influenced our current legal landscape for the better. And now what we want to do, as we sort of foreshadowed earlier, is that we want to unpack some of the trends we've seen in case law, which is developed dealing with sexual harassment.
So I'm going to focus on two trends in sexual harassment case law today. These are related to the amount of compensation received for the impact of sexual harassment on the victim survivor, and the use of legal mechanisms to silence victim survivors. So in relation to compensation, over the last 10 years, there's been a significant increase in the amounts of compensation awarded for sexual harassment under the Sex Discrimination Act. And we can see from the Eklom and Marshall case study that we spoke about before, the Fair Work Commission is taking guidance from those cases in terms of how much compensation to award. The increase in compensation began prior to the Respect at Work reforms, but has been solidified, I think, in the wake of that body of work. The watershed decision for this development was in 2014 with a case called Richardson and Oracle Corporation, in which a whole $100,000 was awarded in compensation for the actual occurrence of sexual harassment. We then had Hill and Hughes in 2020, in which $120,000 was awarded. Then Taylor and August and Pemberton in 2023, in which $140,000 was awarded. And most recently, Magar and Khan last year, in which $170,000 was awarded. Magar and Khan had the highest amount of damages awarded in a case of this type. Compensation of this nature is supposed to reflect prevailing community standards, and the increase in these amounts over time might suggest that this is true. However, the second trend that I'm going to speak about suggests that business interests and business reputations remain more important than the experiences of victim survivors and preventing sexual harassment. So now I'm going to talk about silencing victim survivors. There are two primary legal mechanisms that harassers and employers use to silence victim survivors of sexual harassment. The first is the threat of defamation proceedings, and the second is non-disclosure agreements in settlements. Australia's defamation only favour plaintiffs, so the person saying that they've been defamed, who is inevitably the harasser. So these laws mean that if a victim survivor speaks to even one person, including an internal HR, a psychologist, or until very recently a police officer, and makes an allegation of sexual harassment, they could be defaming the harasser. This means it is very difficult as the victim survivor to defend themselves. Most will rely on the truth defence, which requires them to prove that what they said or published was true. The most recent well-known example of this is probably the Lerman and Network 10 case in relation to the rape of Ms. Brittany Higgins in Parliament House. Not only are defamation proceedings very difficult to defend, but they often involve huge amounts of compensation. The average award of compensation in a defamation claim is 4 times more than in sexual harassment complaints. In the Respect at Work report, the Australian Human Rights Commission heard evidence that these laws are utilised by harassers to deter victim survivors from reporting sexual harassment. More recent research done by the UCID Law School's social justice practitioners in residence supports that evidence, finding that threatening to or actually commencing defamation proceedings is a widely used tactic by alleged perpetrators to silence victim survivors and pressure them to withdraw complaints. This exact circumstance played out in the McGar and Khan case. Now, I'm not going to talk about the conduct in this case. I'm just talking about the part that's relevant to defamation. So hopefully it wouldn't be triggering for anyone. So Ms. McGar made internal complaints of sexual harassment against a senior employee at her workplace and sought legal advice at a CLC. The harasser then sent Ms. McGar 2 concerns notices by his solicitors. A concerns notice is a letter to the person who made the defamatory comments, which informs them that it's defamatory and that the harm it has caused. Fortunately, Ms. McGar was not deterred by these notices and had an excellent CLC solicitor. And in the ultimate decision on her case by Justice Bromwich, His Honour found that these threats of defamation constituted victimisation, so retaliation, which is a contravention of the Sex Discrimination Act on its own. His Honour also observed the quote on the slide. So it is conduct which must be condemned. A person in Mr. Khan's position and any lawyer advising such a person should recognise that resort to threats of defamation action for complaining about sexual harassment is a dangerous course unless comfortably satisfied that the allegations are baseless. Whether this case alone is going to be sufficient to deter harassers and their legal advisors from weaponising defamation laws in this way remains to be seen, but we can hope. The second mechanism that I mentioned earlier was non-disclosure agreements. Now, these are contractual clauses put in settlement agreements or any agreement to protect a secret. They're developed in business to protect trade secrets. However, they're also very commonly used in sexual harassment settlement agreements to protect the perpetrator and their employer from public scrutiny. Respondent lawyers and perpetrators tend to refer to the use of these clauses as standard. I note that there is no obligation on a victim survivor to agree to a non-disclosure agreement. And the Working Women's Centre Australia is currently running an awesome campaign called Our Silence is Not for Sale against the use of NDAs, those clauses in sexual harassment settlement agreements. The campaign has already successfully resulted in a law change in Victoria in November last year. The Victorian government passed the long-named Restricting Non-Disclosure Agreement Sexual Harassment at Work Act 2025, which only allows those non-disclosure clauses to be used where they are requested by the victim survivor, who may understandably want their identity protected or what's happened to them protected. If they request the use of that clause, they have a 21-day period within which to change their mind. If the clause is used without the victim survivor having requested it, it will not be enforceable against them. While this law shows progress, it's not yet law in any other Australian state or federally, despite the development of NDA regulations forming one of the 55 recommendations of the Respect at Work report. However, I have no doubt that the Working Women's Australia Centres will prevail.
So as part of these, the Respect at Work reforms that we were speaking about today, Legal Aid Queensland did receive funding to run a sexual harassment advice clinic and provide legal representation in sexual harassment litigation. So please note a couple of things. We only provide advice and representation in sexual harassment matters to victim survivors, so we don't advise or represent respondents in these cases. Clients are very welcome to call our legal information lines, which will be provided as part of the information after this webinar, and they can be booked in for advice. Alternatively, where clients are already engaged with the service, we can accept warm referrals from those services as well. In our sexual harassment clinic, we take a trauma-informed approach to our advice sessions. So, for example, clients only need to disclose information that they feel comfortable with disclosing. If a client doesn't want to share exactly what happened to them, we can provide general sexual harassment advice and what it is and the legal pathways available to them to make a complaint. And we also have our wonderful social services coordinator, who is a qualified social worker supporting the civil justice services division in Legal Aid. And her role is essentially to support clients to engage with the legal process. So what this looks like really depends on each client and the status of their matter. For our advice clients, this can look like a debrief after their advice session. For the clients we legally represent, this can look like ongoing debriefs, attendances at court events as a support person, and referrals to crisis and counselling services. So to receive legal representation from Legal Aid Queensland, clients must make an application for a grant of aid, and our grants departments perform a merits and means test on those applications. So unfortunately, our means test applies a very low threshold income test. So this can mean that clients who are still working may not be eligible for aid because of their income, but we can always provide advice through our once-off telephone service to assist clients who might be caught in that middle ground. But yeah, that was everything. Thank you so much to everyone for attending, and we can move on to some questions now.
Thank you so much. And also apologies for before, it seemed that we were kicked out of our own session. So thank you to everyone who stayed on. You're welcome to send through any questions. Unfortunately, our Auslan interpreters are booked until 1 and will be logging off momentarily. You are welcome to receive a copy of the recording along with the slides and then send through any questions, and Jessica and Sienna I'll forward it on to them to have someone in the team. Nothing's been submitted yet, so I might just go through some numbers, and if something comes through, I'll quickly read it out. So to contact us for legal information and referrals, the number there is 1300 65 1188. We do have a priority line for Aboriginal and Torres Strait Islander information, which is 1300 65 0143. And there is a separate line there if you already have an existing grant of aid being assessed. That's 1300 383 900. Just going to check, so no questions still. You can order any of the legal aid publications completely for free and sent straight to your organisation. If you just pop onto the Legal Aid Queensland website, find legal information and publication and resources to access and order everything on there. We're still finalising the topic for our next webinar, so please join our mailing list or keep an eye out on the Legal Aid Queensland webinars page for when that will be available. As mentioned before, once this recording has been edited and captioned, I'll send you a link, and it will also be available for free on our YouTube channel, and that will remain up in our webinars playlist until the content essentially changes. And as always, you can follow us on Facebook, LinkedIn, Instagram, and X for upcoming topics, dates, and other useful legal information. Thank you so much for joining us today, and we do apologise as well for the sudden shift last week too, but we got there and it was an amazing presentation. Thank you to our interpreters, and thank you so much, Jessica and Sienna.